Equivalent here is if somebody were to sign a waiver at a motorcycle course, they were to fall in that motorcycle course's gift shop because of an improperly mopped floor without a wet floor sign, and the motorcycle course or club were to assert that the waiver for the motorcycle applied to the gift shop. A brief recounting of facts, I think, is helpful in this case. It's a very simple fall due to a improperly installed bench in a shower. My client was taking a shower, an ADA compliant shower, because she has some difficulties with her legs, and when she sat down, the chair came out, she fell down, tale as old as time. Upon discovery, we found, and the defendant's witness essentially admitted that the screws were improperly fastened to the wall in this ADA bench. But the facts aren't while helpful or not the main reason we're here today. The main fact or the main issue of law is the contract that my client signed to join this YMCA. And specifically the provision purporting to exclude liability for YMCA due to any use of their facilities. Here there's both a question of contractual reading and a question of statutory law as to whether, if their reading is correct, that contract could even be enforced. To start with the construction element of this case, as you all read in the brief, the main turn of phrase is around the phrase facilities. January is also a relevant month for this case because many people are starting to go back to the gym, myself included. As somebody who has been to gyms and has used gyms, my gym has weight machines, saunas, tanning beds, etc., etc. I don't think a reasonable person would assume that things like the showers that they provide patrons, the restrooms, the ceilings, the areas where you're allowed to buy energy drinks or protein shakes would count as a facility as a normal person would understand it in the context of a gym or a health club.
The word facility, is it modified in any way in this contract? Is it like gym facilities or exercise facilities or anything like that?
No, it is just facilities, but I would submit that you cannot divorce the fact that this is for a gym from the term facilities.
So as I understand your interpretation argument is, the context here is what leads to a narrower definition of facilities. Is that a fair characterization of your argument, or am I missing?
Partially that, as well as the phrases before it that kind of modify or give more context to the meaning of the term. Both the context around the phrase facilities as well in the contract, as well as the context of this being a contract for membership at a gym or a health club, I think it results in a reasonable reading that would at least survive summary judgment, and I would argue be the most reasonable reading of the term.
Well, so the waiver your client signed says she's releasing the Y for injuries or damages resulting from participation in activities or programs, but then it says, or my use of such facilities.
Mm-hmm.
It seems to me that makes it broader than just activities or participation in activities or programs, does it not?
I would argue that a fair reading of that would be activities or programs being classes, clubs, programming that the YMCA puts on for the public, and then facilities is just like unprogrammed activity like taking a swim in a pool, using a weight machine.
Well, equipment is listed separately.
Right, and we would argue that equipment modifies that and is just, yes.
Use of facilities, equipment, or machinery. So doesn't that mean each of those words has a slightly different, or at least a slightly different connotation?
Yes, I would agree with that, and I'd argue that facilities can be reasonably read to include stuff like yoga classes or, swimming programs, which might not necessarily fit under one of the other definitions, but still a reasonable person would read those prior terms as modifying facilities to not include simply the entire property. And that's another point I wanted to make. In the pleading, they say opposing counsel asks what precisely they could have said to include everything they wanted to. I would argue that it's actually fairly simple and wouldn't even be that difficult. Just say the property, which would encompass the ceilings, as their representative said in deposition, as well as bathrooms, waiting areas.
We don't have to worry about the ceiling in this case because your client wasn't injured by
Right.
ceiling tile. But, I mean, facilities, though, I mean, is colloquial understood to include the bathroom area. So, to me, that is an apt word to use to cover showers.
Again, I would go back to the context of this being a health club. I'd also argue, while that might arguably be a reasonable reading, although my client disagrees, there is still other reasonable readings out there in the context of this being a health club, and we'd at least survive for summary judgment purposes.
Let me ask you about your alternative argument about even if it is covered, we shouldn't enforce this contractual provision. And you spend some time in your brief talking about public policy here and
Yes.
public policy not favoring. I mean, what about the public policy, though, that people should have several options for health facilities, and part of what allows an entity like the Y to be around is these sort of waivers or exculpatory clauses in contracts. I mean, what about that policy?
Yeah, and I'd certainly agree with that, and that's kind of where the analogy in my first portion comes from. We agree, if this had happened in a weight room, if something had happened in a sauna, if something had happened in a pool, she contracted to be at a health club, and therefore, as a result, any kind of waiver would reasonably, the waiver for facilities would be incredibly reasonable here. In this case, it wasn't related to physical activity. She was just taking a shower. So our argument for public policy is that we completely understand that with this waiver, she to some degree contracted and put herself at the risk of being injured for physical activity. That is not what happened here. And if they wanted to do it broader than that, it would be very simple to tune up the language, as well as simply bold and specify, hey, you're waiving everything here. This is the waiver, instead of just saying there is a waiver somewhere in this several line wall of text for a unsophisticated party.
But I guess my point is, doesn't the public policy also cut the other way, is that if we make a determination that this is not enforceable, what that amounts to is we're saying, okay, well, you need to up your fees because you need to protect against additional exposure, because we're not going to allow you to do this broad waiver.
As Tennessee case law applies, I think that simply tightening up the language and doing something to point out the waiver specifically would satisfy the law here, neither of which were done in this case.
Well, what more could the Y, I mean, I'm assuming you're suggesting maybe that the waiver clause itself could have been a bigger point type, but
yes.
I mean, there is in 30